plaintiff's motion for petition by sale of real property. Ms. Nguyen, I have had a chance to review your proposed order. I understand that Mr. Olinger may have some concerns. So I'll turn it over just briefly to Mr. Olinger to let me know his thoughts on the form of the order, and then we'll go from there. Mr. Olinger? Sorry, can you state your name for the record?
Brian Olinger.
Thank you, sir.
No problem. I was just hoping to try to dispute having to pay the lawyer fees, and then also, I guess, clarification on moving the process forward. I've got an attorney a realtor. I'd like to get the house sold and get this thing moving forward in the right steps. I do recall Miss Nguyen on our last case had said something about a buyout. I don't know if that's even able to be talked about today or not, but I just, after you had said our last court date, if I wasn't in full agreement to show up, I just wanted to make sure I wasn't missing an opportunity and to be here to make sure I was.
No, certainly it's no problem for you to be here. So that's not a problem at all. If you have any concerns, that's why we set it for today.
Right.
So it does sound like you got a copy of it, correct?
Yes, sir.
Okay. So a couple of things. One, you don't have a dispute of the address of where the property is located in paragraph 1, correct, sir?
No, Your Honor.
Okay. So paragraph 2, the real property shall be sold by a receiver. Ms. Nguyen, in the statute RCW 752.480, I'm sorry, 752. I think it's 080 actually. It uses the statutory term referee rather than receiver. I understand they may be interchangeable, but my thought is to change that so that it conforms with 752.080 and use the word referee there just for clarity. Do you have an objection to that?
I do not object. They essentially achieved the same thing of what we're hoping to do.
And so, sir, the short answer to your question, and I'm going to add a paragraph on this. So Ms. Nguyen, you can think about language on this on a paragraph number 5. But my order last week was that it be appointed or it be sold via a referee. What that is someone independent who would make an independent judgment as to who to hire as a real estate agent. Now, potentially that referee could be a real estate agent. It could also be an attorney. And so what I said, and I think maybe Ms. Nguyen does have this in paragraph number 2, is that she was going to file a motion suggesting maybe 1 or 2 or even 3 individuals to fill in that role. And then you could agree to one of those, or you could suggest your own 3 individuals to fill that role, up to 3. And then the court would then determine who to hire to oversee the sale. So that person could be a real estate agent. That person might be an attorney, and you would have a right to have, just like the plaintiffs would have a right to have a person that you are interested in potentially being chosen by the court. Does that make sense?
It does. So just, but we can work on someone neutral that we can agree on in some sort of sense. Okay.
Yeah. Ms. Nguyen, maybe now that I look closer, I think the appointment shall be made on motion by plaintiff. Maybe what I could just do there is insert and defendant shall have the opportunity to nominate his own referees, up to 3, or something along those lines.
Yeah, sure. I just wanted to get to the point that we are going to present it in a motion in a hearing.
Yep.
That's
yeah.
And then as far as placed in the escrow, is that essentially, so the referee, when that is finally decided, the house goes through the sale process, and then once it's sold, everything would go through this escrow account first and then be dispersed as you stated?
Generally, Ms. Nguyen, maybe you can answer that better, but generally what an individual or a plaintiff would have to do is come back to the court and then ask for access to that 50% post-sale. Is that generally your understanding, Ms. Nguyen?
Yes, correct, Your Honor. So it's placed in a neutral escrow title company account with expenses and loans and liens paid off, and then that money stays there, and then we come back, or defendants, each side, again, another hearing is set, and we seek for a disbursement of.
Yeah, there's no self-help to money here by either side.
Understood. Understood. And again, I guess I was more concerned because I'll need the funds to relocate once the house is sold.
Understood.
To my current residence, and so I just want to make sure I was covering my butt.
Understood. Plaintiff is granted leave to present her petition for attorney's fees and costs incurred in the petition and sale pursuant to RCW 752-480 and RCW 484-010. They've asked for those attorney's fees and costs, sir, and generally they are entitled to them. Now, again, they don't just get to make up whatever number. They'd have to file a motion to court and say, here's what our costs and our fees were. And then the judge would independently decide if that's a reasonable amount or not. But it's not, they don't just get to take that money out of the escrow just because that's what they think their costs are. The issue that you raised with respect to a potential settlement, certainly things are always subject to potential settlements, but that's not something that I get involved with. That's a conversation you would have directly with Ms. Nguyen on behalf of the plaintiffs, but it's not
an option that I could reach out to
I
her.
have no idea if it's an option or not, but that's something that you would need to reach out directly to Ms. Nguyen about. It's not something that the court would get involved in.
Okay.
Okay.
With that. I guess, and the only other question I had is due to the fact that she hasn't been living there for a handful of years, does any of that affect as far as what the equity is, or because I've obviously been the only one paying on it and she hasn't been a resident there for almost 3 years now, does that affect the portion of her entitlement because of the?
Well, no, we're beyond that.
Okay.
Because they had put in their petition a request for 50% of the proceeds.
Okay.
Your answer was then struck primarily due to the lack of, as I understood the case file, I didn't hear that.
Right.
But lack of discovery responses, among other things. And so that's now affixed at 50%. It's not really at a position where we're at today.
Okay.
that is subject to change. Is that a fair assessment, Ms. Nguyen?
Yes, I agree, Your Honor.
Okay. So let me make a couple of, the only paragraph I'm going to make some notations on is paragraph number 2.
May I ask Ms. Nguyen a question?
Yeah. No, I don't. If you're welcome to talk to her or send her an email after the hearing, but it's easier for the record if we don't have parties directly conversing on the record.
Understood.
Give me just a moment.
No problem. Thank you.
Here's what I've put in paragraph number 2. The real property shall be sold by a referee. Appointment shall be made upon a motion by plaintiff, comma, defendant shall also be allowed to nominate up to 3 referees by motion, and directing that the sale of the proceeds, or directing that the proceeds from the sale be placed in escrow. So again, Ms. Nguyen can file a motion suggesting 3 people. If you want to file a motion suggesting 3 referees, you can do so. And then, of course, if you file, sir, just to be clear about this, if Ms. Nguyen files her list first, you need to get it in so they're both heard at the same day, because if the court has already decided from Ms. Nguyen's list, you can't later go back a month later after that decision and try to file your own 3. Okay. So you need to have those heard at whatever the same time.
Stuff and have a chance to respond and all that. Like
she's required to serve you just like you would, like in any other hearing.
And then my only other question, Your Honor, is on the paragraph 4 there, partition for attorney fees and cost incurred in partition and sale pursuant. Does that mean that any of the sale fees or taxes and stuff like that, as far as that she's requesting that I pay her pay all the taxes and fees for the sale of the property, and then she.
I don't think that's what that's intended to
Okay.
mean. But that's probably not a bad idea to clarify that. Ms. Nguyen, what I assume you're asking for here is meaning the filing fee and any deposition cost and attorney time cost. You're not talking about like real property taxes and realtor fees.
Oh, yes, Your Honor, none of those. So it's pertaining to just the lawsuit, the cost of filing the lawsuit, bringing the lawsuit, attorney's fees. And I'm assuming once a referee is involved, my involvement would be very minimal.
Yeah.
And so there wouldn't be a lot of fees thereafter up to this point. So it's attorney's fees and costs incur. I see what you mean, I guess, in the partition action lawsuit.
Yeah, I think we could either put in incurred up to the partition and sale, or I could just leave leave the word in alone and then put attorney's fees and court costs.
Right, attorney fees and court costs.
Why don't I just put court costs? I think that's the cleanest way to do it.
Yeah. I do anticipate some of my fees later on. But I feel it would probably be minimal just because we'll have a referee in place.
All right. I've signed off on that order as I've read it and edited. Sir, if you want to copy this, there'll be a copy probably by Monday down at the clerk's office. You can get a copy. There'll be a copy available, Ms. Nguyen, on Odyssey as well. And I'll go ahead and hand forward that order for signature today. Thank you both for being here. I appreciate your time.
Thank you.
All right. Thank you, Your Honor. Have a good
All right.
weekend.
Have a
Thank
good
you.
day. Let's next.